Subscribe to the channel for more content. Judicial custody vs police custody and arrest vs custody vs detention. The former Delhi deputy chief was sent to judicial custody in a liquor policy case. About arrest vs custody vs detention. Arrest. The term arrest is not defined either in the Code of Criminal Procedure Code or the various substantive acts. The word arrest is derived from the French word arrêt, which means to stop or stay. An arrest is a restraint of the liberty of the person. An arrest is an act of apprehending a person and taking them into custody, usually because they have been suspected of committing or planning a crime. Custody. The control and care of a person or property, especially when granted by a court. Custody is the state of being guarded, or kept in prison temporarily, especially by the police. According to Section 27 of the Indian Evidence Act of 1872, the expression, in custody, denotes surveillance or restriction on the movements of the person connected. Difference between arrest and custody. An arrest is a mode of formally taking a person into police custody, whereas custody merely denotes surveillance or restriction on the movement of the person concerned. A person may be taken in custody completely or even partially. Thus, in every arrest there is custody, but the converse is not true. Detention. When the police or any authority holds someone under suspicion of any illegal act but has not charged them with a crime is known as detention. The person is detained against their will and their liberties are revoked for a time being. The police have the right to detain someone if they suspect them of unlawful activity or any wrongdoing. However, the police cannot detain somebody without reasonable suspicion, and can only detain them for a certain period of time which varies from region to region. After the prescribed time, the police must either release or arrest the person according to the case. About judicial custody vs police custody. Police custody. When a person is arrested by police for charges of committing a heinous crime or on suspicion, he is detained in police custody. A person is kept in police custody after he is arrested on the basis of infer or suspicion. The period of detention is 15 days. A person in police custody is kept in prison or a cell at that particular police station. The investigating authority can interrogate a person. The person has the right to legal counsel, and the right to be informed of the grounds which the police have to ensure. The rule to produce a person before a magistrate within 24 hours of arrest is given under Section 167 of the Criminal Procedure Code, 1973. The person arrested must be produced before the magistrate within 24 hours, and if charges are not proved, then he is granted bail, or else he is sent back to police custody for further investigation and interrogation. The magistrate has been given the power under Section 167 to remand a person in police custody. He can also order to change the custody from police custody to judicial custody. In such a situation, the time period of police custody is deducted from the total time period of judicial custody. Judicial custody. It implies that the accused is lodged in jail and is under the custody of a magistrate. The person detained under the purview of the judicial magistrate is lodged in central or state prison. While in judicial custody, officials need the permission of the court for questioning. In the case of non-bailable offences, punished with life imprisonment or imprisonment not less than 10 years, the period of detention is 90 days, and in bailable offences, the maximum period is 60 days. A person in judicial custody is kept in central jail. The person is kept in judicial custody on the orders of the magistrate until and unless he is granted bail. A person is kept in judicial custody after the public prosecutor makes the court believe that such custody is necessary for further investigation.